Under my microphone, so sorry. Good afternoon, ladies and gentlemen, and welcome to the meeting of the Georges River Local Planning Panel for the 20th of July 2023. My name is Sue Francis and I'm the chair of this panel, and the panel is currently being streamed to the council offices in McMahon Street, Hurstville. The panel members who make up the panel today are Judy Clark, expert panel member on my left, Anthony Hudson, expert panel member on my right, and to my far left is George Vardas, who is a community representative on the panel. And we're the panel who've been appointed by the Minister to determine the applications on the agenda today, and I think we have 5. Before we go any further, Georges River Local Planning Panel acknowledges the Bidjigal people of the Eora Nation, who are the traditional custodians of all lands, waters and sky in the Georges River area. We pay our respects to elders past and present and extend that respect to all Aboriginal land, Torres Strait Islander peoples who live, work and meet on these lands. Now, it's important for me to advise you that we are live streaming. Whilst we have people actually in the chamber today, we also are live streaming, and so some representations will be made electronically. We have 5 registered speakers today on how many items? On 3 items. The first item on the agenda is 37 Princes Highway, Kogarah, and I have 3 speakers, and I will call you as relevant in this order: Jessica Bates, Bernard Morose and Elaine Asselm. The next item on the agenda for which I have speakers is 20 Russell Street, Oakley, and that's Nick Hibbard. And then lastly, the speaker I have is for 118 to 123 Princes Highway, Beverley Park, and that's Christy Hodgkinson. They are the speakers that we will hear tonight. Now, just for clarity, all members of the panel have provided declarations of any pecuniary interests, and there are none, but just for the record, I'd like to go through everyone to declare publicly about whether they have any conflicts since then. So I'll start off with George.
Not that I know.
Okay, thank you. No.
Not that I know.
No conflict of interest.
No conflict of interest.
And I have no conflict of interest either. So just to go through the process of the meeting, we will only speak to those people who have registered, which I've just mentioned. Each person will have 3 minutes. We may or may not ask questions. We may just move on with the issues if we're aware of the issues. I'd like to remind people that because we're streaming, to speak the particular volume. That might mean you have to remember to keep putting on your microphone, which is what we all forget to do. And also, because we're live streaming, please be mindful of what you say. This is public and you'll be on the internet, and then council takes no responsibility for what you do or say. Now, we will not make any decisions on the item until we finish the agenda, and then the decisions will be made and they'll be posted on council's website in the next few days. So don't expect a decision each item. They will be in the next couple of days, which we will do when we close the meeting. With that being the case, I think we'll call the first item, which is being heard when we're having representations online. So the first speaker I have is Jessica Bates. Can we get Jessica? Jessica, oh, there you are. Jessica, can you hear me?
Yes, I can. Thank you, Madam Chair.
Fantastic. The floor is yours. You have 3 minutes.
Thank you very much. So, Grace Lawyers, I'm from Grace Lawyers. We're a strata law firm, and we act on behalf of an owners corporation who is actually the owner of the neighbouring land that's the subject of this proposed first agenda item. We've previously raised an objection to the development. The submission that I make today is a very narrow issue, and it's simply about there's an existing easement that burdens the common property of the owners corporation. In a nutshell, what we're talking about on a practical level is the building has 3 basement levels and it has a secure door. There's 84 car spaces for the existing owners in our building, and there's about 16 visitor parking, and there's a car wash bay, and there aren't any bollards to restrict access. So what happens is a vehicle that comes in through the door, which is a secure door, has unobstructed access to come in through the car park. And they also at the moment are able to get out of their cars and go to the lift and go up into the lobby into our building. So that's the current setup. So at the moment, there's this easement that doesn't give effect until such time as this development consent is approved, and then obviously the building's constructed. And that's all fine that it's been set up that way. The difficulty is, though, is that at the time it was set up very minimalistically because of the situation. But because of what's going to happen with this proposal, the reality is that it is going to have a detrimental effect on the owners corporation. So a very simple example is this. I think it's proposed 33 new vehicles are going to be, there's 33 spaces for this new development. So there's at least 33 different vehicles that are going to be able to come through the owners corporation's building. And for that purpose, they're going to have to actually get through the front door because it's a secured door. And as I understand it from the building manager, it's about $150 per remote key. And so just the process of setting up those keys, there's a cost to the owners corporation to do that. And obviously to keep dealing with issues that come up because people lose their keys, etc. And the overall, there's a building manager that's engaged. So the building manager is going to have to then obviously deal with any issues that come up from time to time. There's also an issue that we face now with do we have to then reprogram the lifts because we don't want the potential for people who are passing through to go to the other building to then potentially have access into our building. They can illegally park in our visitor car parks, and we've already got issues with that. We've got issues with is the roller door actually going to be sufficient because it's going to have to open and close for more periods of time now. And so then do we have to do an upgrade and get a better door because we have to use it more often? We've got the general issues that we face when there's more people in any building. We've got the risk of more accidents, personal injury, damage, all that sort of standard stuff that can happen from time to time. As I understand it, there's going to be some storage and bicycle parking spaces. So although the easement at the moment is limited to vehicles, ordinary human beings don't read easement. So there'll be a potential for foot traffic and bicycles in addition to vehicles. So again, there's more people travelling in the vicinity. The overall everyday repair and maintenance. So there's bylaws in strata. There won't be any bylaws that will impact on the neighbours that will affect them because they're not bound by them because they're going to be they're going to be residents in a neighbouring land. And so overall, all the owners corporation is asking for is for council to impose a development consent condition that allows for the easement to be varied because the council already has that power to then allow for the parties, the neighbours to actually come up with a system that allows for all these things that are just normal realities, but they allow for there to be some fairness in the situation. I would submit it's in the, apologies if you can hear there's a noise in the background in my end. It's in the public interest that an existing owner, whilst it's ordinary to be burdened from time to time by easements, but not to such an extent where they're actually having to go out of their way and pay additional costs that they normally wouldn't have to. So the typical example is if we've got a patch of land out on a farm, that's a usual example, and you have the right of way to pass through and it's an open area and all you have to do is have a fence to go in and out, whereas this one's much more complicated. And in terms of like all the council has to do, as I said, is impose a single consent condition that requires this easement to be negotiated and approved by council, and then that'll provide some protection for the owners corporation and also assist, I think, the parties actually as well to be able to have a system in place for dealing with all these things rather than having a fight that might end up in the court when it can be more simply dealt with at the development stage. I think that covers it, and that's probably my 3 minutes, Madam Chair.
Thank you very much. Just a question from me. I perfectly understand the issues that you're raising. I'm just wondering whether an amendment to the easement, I do have a lawyer sitting here, so I can ask him, but I am wondering whether an easement variation is the right tool, because I don't know whether some of these things can be put into an easement per se. I'm just asking this naive question, not being a lawyer, whether there's an alternative tool, conditions of consent that may, on any development consent, to address these issues, such as insurances and body corporate amendments, or other than the easement itself, because the easement's quite a blunt tool. It just says A to B basically, and you may pass. It doesn't deal with detailed nuances like, insurances and cost payments.
So, Madam Chair, in easements we prepare from time to time, we actually do make them quite a bit more prescriptive than the standard wording, and we do cover things like indemnities and repair and maintenance. There's also obviously positive covenants, so it might be that there might be a combination that could be imposed. I think ultimately, if there's some flexibility for the parties to come up with something, then that's great. So it might be that if council was minded, the development consent condition would say an easement and or positive covenant restriction on use of land, so that there's the combination in there. And we've just had a matter where we've been dealing with slightly different, but having two different neighbours accessing a pipe that's actually on council's land. And in that matter, of course, it was different because it was on council's land, but that one was wrapped up via a positive covenant in relation to repair and maintenance. And there was a process in place for, how do we actually trigger, there's an issue that needs to be repaired, how do we trigger it? And so we actually had wording in there about how you trigger the fact with, one party saying, hey, we need to fix something. And then there was a process and a dispute resolution process in there as well. So in my experience as a strata lawyer, there's issues all the time that come up. And because this isn't a horizontal build, we don't have the luxury of having a strata management statement and a building management committee who can deal with what really becomes shared facilities. So we have to kind of deal with it in a different way. And that's why the Owners Corporation is proposing if we can have the ability to, with council's assistance, because you do have the power already, to come up with some terms, whether it's in an easement or positive covenant or both, that actually, realise the practicalities of what we face, because sometimes the legal side forgets the practical side, and this is quite critical when we've got human beings, using a car park. We want to protect everyone, but we also want to be fair in the costs that are incurred. So I would hope that there'd be some ability between those two documents to come up with some, sensible wording that will actually be in the best interest of everybody going forward to try and alleviate disputes.
Okay, thank you.
Sorry, I should say one other thing. Sorry, in the other matter we've just been doing as well, we also had a deed that we've attached to the positive covenant, and that covered some additional things as well. So there was that side of it as well. Sorry.
Okay, thank you very much. Any other panel members? Any questions? Yep. Okay.
So you mentioned just at the end of the first part of your submission that if you didn't have something like you suggested, or you couldn't come to an agreement, you'd have to then just rely on whatever ancillary rights might be as the way the easement is now. Is that what you meant? Like when you said you'd have to go to court and argue about it, however this extends to cover those type of things, the existing easement, I mean.
Yeah, I think we'd have to look at extinguishing the easement because it's not working. But yeah, in any event, it's a battle that I don't think the parties have to need to have in the scheme of things.
And just the last thing, when you say a positive covenant, what sort of thing were you thinking of that would cover in this particular situation?
So similar to the one I was just giving an example of, we could actually cover the shared costs effectively that arise. So shared costs of insurance, repair and maintenance. If we have to do extra security, the building management costs, because they're going to have to deal with the other human beings who are coming in and out with access codes and things, because they have their own management fee that they pay every year. So all this work would be additional work. So that as I said, it would be actually covering all those, the standard things that are going to happen.
Yep.
Cleaning. Yeah.
Yeah, I think I understand. Okay, thanks very much.
Thank you very much.
Thank you. That's no other questions. Thank you very much indeed.
Thank you very much.
Thank you. So we'll now have, I think the next speaker is Bernard Morose, who's the planner for the project. Are you there, Bernard?
Hi, Madam Chair, panel members.
Hi.
I'll probably refer over to Elaine, Madam Chair, who was the architect, just to give you just a quick or a brief summary of the proposal, and then I guess we're open to answer any questions the panel may have. Madam Chair, also probably worth noting, we have Ms Johnson available also, who is our client's legal representative. If you would like to direct any questions in relation to the easement to her, she's here to, will hopefully assist and answer any questions you may have.
Thank you for that. What I would like is for Ms Johnson or yourself or whoever to actually respond to the concerns raised, yes, and how you might see the solution.
Ms Johnson, you there?
Yes, I am here. Thank you. Thank you, Madam Chair. I suppose from the applicant's position, its view of the world is that the easement has been known by the owners corporation since the beginning, since before they purchased the properties. And so it shouldn't be something that holds up the development. I understand that they would envisage that the parties could enter into some sort of agreement outside of the easement or a positive covenant to deal with the issues and the concerns raised by the owners corporation for the neighbouring property. Their main concern is just not being held to ransom by the owners corporation to be able to keep that easement or use the easement that it's got the right to.
Right, but I think what was being suggested by Ms. Bates was not unreasonable. I'm asking you what you would see as the solution. Not what you don't want. What you do, what's the solution?
No, I appreciate that, and I think the client's pragmatic and understands that there are the concerns, and it would be happy to try and address those concerns. But I think that would need to come through discussion with the owners corporation to find something that would be mutually satisfactory to both of them to address those concerns of security, the additional costs, things like that. And I think they would be happy, as I understand it, to enter into some sort of agreement with the owners corporation that Ms. Bates represents to be able to do that.
Just as much as I suspect your client doesn't want to be held ransom by the applicant, it works exactly the same the other way around. The body corporate for the neighbouring property wants this matter resolved in terms of how's that going to be addressed. So you don't have any particular suggestions in terms of how one might word a condition, if that were an option to get this addressed?
Not at the moment, I don't.
Okay, thank you. Any questions, Ms. Johnson, while she's still on the call? Okay, thank you.
Sorry, Madam Chair, this is Alan from Fuse Architects.
Yes.
If I could just add to that, so in our experience where we've delivered a similar building in Auburn, where it was for a shared easement for the neighbouring property, so it's pretty much exactly the same as this, is what's happened is, and if I can suggest this, is that the owner of the development that was utilising the easement agreed to upgrade the roller door and also the fob system so that there was a clear separation between the two. And then any additional signage in terms of wayfinding and directional was up to the new development to their costs. So in terms of the other things that were raised, like cleaning, insurance and things like that, I think what the panel, I suppose, should also consider, it goes both ways, is that utilisation of visitor spaces isn't necessarily just the ones of the existing building, but also of the proposed building. There's a risk that it kind of goes both ways in terms of the management of that. Same thing with cleaning and insurance and things like that. Again, on the precedent kind of project that we've been involved with, that was completed as of a year ago, is that I think under the terms of the easement and that the cost in terms of the security system and the fob system were at the expense of the new developer, that they ensured that there was a secure system. The roller door was upgraded at their expense as well with the intercom system, because you need to upgrade the intercom system because the new residents need to have access to that as well. So at the same time, that was upgraded for both buildings at that garage point or that vehicle access point. But in terms of insurance, cleaning, in our experience, that's not something that in a practical way can be shared between the two in these built examples. And then again, being involved in these projects in the past, what we found is it hasn't been an issue up to this point. So again, we've been involved with kind of post-occupancy evaluations, rectification works where needed on an ongoing basis. And what we're finding, just because we're asking about it, is that it hasn't been an issue from an insurance and cleaning kind of perspective. But I take the point regarding security, and I think the security aspect can be easily dealt with an additional condition of consent if the panel felt that way.
Okay, thank you very much. Right, so I heard that you were going to run us through the design, is that correct?
No, so the way we feel is that we've worked really hard with and a kind of lengthy process with the council officers. We've read through the assessment report. We're fully supportive of the council's assessment report and recommendation of approval, of course. So we're here generally just to answer any questions from the panel members if they arise, if they've got anything specifically that
Okay,
any clarification.
no, that's absolutely fine. So I will start, given it's you on the call. So I am very concerned, and I don't see how you satisfy the ADG for solar access to the units. Because, and let me explain why. Your northern face and the windows that you've indicated on your solar scenario diagram, without actually indicating the 1 square metre above 1 metre high, you haven't actually nominated that. You've indicated that these are the doors or the bathroom windows or bathrooms of those units, which are beyond the corridor. So I'm not convinced the sun will get in through the tiny little highlight on the top of the door, nor do I think it will get to the living areas, unless I'm misreading these plans. That is the 1-bedroom units on the northern face.
Yeah, so I suppose to answer that query, it's a side light next to the, so if you refer to the plans, specifically if you want to, level 5 to 6, you can kind of say the windows are adjacent to the doors.
So that's a bathroom window.
No, it's not a bathroom window. It's opening to a corridor.
Yes.
And that provides the adequate sunlight to these apartments. Again, I think, as you can appreciate, it's being a kind
into the living area,
into the corridor space, into the apartment,
into the space behind the door.
Well, not behind the door, but yeah, into the corridor space.
So not the living area.
I can't answer. Sorry, I can't.
Okay.
All the way into the living area.
Okay.
Yeah.
So that being the case, there's a significant, if I held that to be the case, or if the panel held that to be the case, that's a significant non-compliance with solar access, is it not?
No, I think the ADG talks about access into the living area, and in the corridor we deem it as part of being part of the living area. It's not excluded from it in its studio apartment.
Yes, but it's the corridor behind the door and before the toilet door, bathroom door.
In that one circumstance, but the other circumstances, it's not behind the door.
Okay, all right. I'm just talking about the 1-bedders.
And the studios, they're not behind the door. I think there's one example on level 5. The other 4 examples are not behind a door.
Okay, we'll have a look at that. And the other aspect, I just want to double check your communal open space in the intermediate level, which doesn't get any solar access at all. Well, it might get it from the west in the afternoon, but I'm not convinced that it does because of the building that's there. Are you relying on the solar access to the rooftop?
Predominantly, yes.
Okay, so you're saying that's 2 hours, 50% of the communal open space, is that right?
Yeah, that receives more than 2 hours. That space on the roof, as you can appreciate, being open to the sky, receives the whole day solar access.
All right. Okay, thank you. I'll ask the other panel members if they have any questions.
Yes, I'm looking. Oh, sorry. I'm looking at the. Just got to call it up again. The statement of environmental effects. Paragraph 4A dealing with solar access, which is on page 33 of the statement of environmental effects. I don't fully understand what is meant by this. It addresses the issue of it recognises, it claims a maximum of 15% of apartments, and this is following on from what the chair has raised, will receive no direct sunlight. And in the commentary, it says, notwithstanding the shortfall in solar access provision, each nominated apartment enjoys a primary orientation towards the street road frontage, whereby a greater level of occupant amenity will be naturally enjoyed, which for the purposes of this numerical dispensation will facilitate higher degrees, despite the solar access non-compliance. I don't really get what that's saying. Can someone respond to that?
Yeah, George, can I ask you, the statement you're referring to, what's the date on that statement?
Well, it's in the package that we were given.
Yeah, and what's it dated?
Just bear with me. September 2021.
Yeah, the design was amended post that, and an additional SCE was prepared subsequent to that. I think that the SCE you're referring to is related to the original design.
All right. Thank you.
Okay.
Sorry, could I just return to that? I take it. I don't have that in front of me, the revised statement of vulnerable effects. How did you address it in the revised statement? How was it revised? Can you take us through that?
The apartment configurations were reconsidered. There were a number of, a level of the building came off. There were a number of design changes made across the building that facilitated let's call it a greater degree of solar access or solar penetration through the building.
So is it contended that there's more than, I think, as I said to you, reading the original statement, you can see that there was a 15% got no sunlight. Have you revised that figure upwards?
It's less than 15% to answer the question.
Oh, sorry, I say revised it downwards, yes.
Yes, that's correct.
That's correct, yeah.
Thank you.
My pleasure.
The other thing to note, please, is that at the moment, while in terms of solar access, is that I think that statement that you're looking at is 67.5% in terms of 2 hours of solar access for the shortest day of the year for the apartments. Noting that the size of the apartments is that the revised scheme that we negotiated and refined with council's input achieved the solar access of 37% in the ultimate scheme that's before you.
Sorry, can you clarify that? What's the solar penetration access? Did you say 37? 37?
Sorry, 73%.
Okay, thank you.
Sorry, I did. So thank you, Madam Chair. It's been one of those days.
I might say you're right on 37%, but let's not go there now.
No, I don't think so. No. Madam Chair, you can appreciate it as being a site isolated site with the pressures that you have. Unfortunately, I think we probably all know the history of the site and the gentleman that owned the land previously, and him holding out. I think it had a lot of local media traction at the time. Ultimately, the site should have been developed comprehensively as one site, but unfortunately, this is a situation that we're all kind of been left in. And I think we've designed a building that addresses the street, presents the building quite well, with outlook out for the residents, dealing with the compliance of the ADG, ensuring that the amenity of the neighbouring building is protected as well as we can. And I think you can kind of a reflection of that, I suppose, is the neighbouring building's lawyers from Grace noting, I think, their concerns regarding the registered easement and the practicalities around that as the only item that they've kind of flagged today, as I think that demonstrates that I think what we've done in terms of the design is quite sensible, dealing with the constraints that we do have, noting that the neighbouring building is only flagged out as their kind of concern. But I think again, yeah, we've dealt with very difficult constraints and working with the council officers really closely, from waste to traffic to the planners, to come up with a solution that will kind of hold that corner quite well, but provide a high level of amenity for the future residents within our development under the circumstances, but also protect the amenity of the neighbouring buildings.
Thank you, Doug. Just one further question. The windows that face north, so face onto the gallery corridor, which faces onto the adjoining apartment building, that you're claiming for solar access, are they openable or not openable? Because they're on the
They would be openable.
Okay. Thank you. No other questions from any of my panel members. Thank you very much indeed. Alain, unless you wanted to say anything?
No, I'm fine. Thank you for your time and consideration, and yeah, we look forward to hearing from you.
Okay, thank you very much. I think what we'll do is we'll close this item. We'll move on to the next one. Thank you very much.
Thank you.
Thank you, Madam.
So the next item that I have a speaker for is 20 Russell Street, and that's Nick Hibbert. Please come forward. Remember to put the microphone on, which is what I keep forgetting to do.
Thank you to the panel. I'm the applicant on this particular project. After a long consultation process, pre-DA and a long DA process, I think we've come to a substantially pretty good outcome on the report for this. There were a number of legal issues relating to the right-of-way that we have worked through with our surveyors to hopefully address all those issues, which hopefully satisfies all the concerns of the neighbours. We would ask that Condition 7, the only design change that was applied retrospectively to the previous discussions, we ask that that be looked at to be modified to result in a better outcome for the subject site, but also a better outcome for the neighbour in question. Condition 7 addresses a perceived acoustic and privacy issue between the rear deck of number 18 and the rear deck of number 20. Now, these properties are built very close to the rear boundary. It's just sort of a peculiarity of it.
We've been there this afternoon.
Yes.
Yeah.
So the condition proposes that the planter box between those two decks is increased by a further 1.8 metres. Now, if this change happens, it means that there's substantive access issues that become prevalent from the living room space out into that deck. So when you open the rear door, walking into a planter wall. And then it's also the case that there's negligible benefits to number 18, we believe, with this particular planter. Firstly, because the conditioned extra planter will result in no increased visual privacy, given the levels of the deck. The top of the privacy screen will still be the relevant thing, and there's no change in this condition to that privacy screen. But also that by moving it further away, you're moving it away by maybe an extra 1.8 metres, and the drop off in sound is pretty negligible over that level. You're probably looking at a drop of 2 decibels for something like that. I'd like to note that the owners of my client enjoys fairly good relations with number 18, and so we would like to ask that we possibly modify the condition to create a better outcome for the neighbours that doesn't substantially affect the subject property. We believe that if the planter is kept in its current configuration, and then the privacy screen that is currently there is changed to an acoustic privacy screen, something with an RW value of possibly about 10, that will give you a 10 decibel difference generically between the two properties, which is about 5 times what the increase in planter is likely to do. Yeah, that's really the only change that we can really see that's an issue. But obviously, if you've got any other questions regarding the wider application, I'm here to answer anything you've got. Thank you.
Thank you for that. Just because I'm reading this off a very small plan, am I right in saying that the plants or the greenery going into the planter as it currently is blueberry ash
That's right, yes.
to
They
a
go,
height of 4 to 6 metres?
yeah, that's correct,
Okay,
yes.
just wanted to clarify that I can read that. Okay, thank you for that.
Yes, you do have plantings in there, sorry.
Any questions?
That's green, that's just at the end of that bed we're talking about.
That's correct, yes.
The
You've got,
western elevation there, yeah.
that's correct, yes.
Any other questions, elements?
Just briefly, you mentioned that the your client and the neighbour enjoy friendly relations. We noted that no objection was lodged by the neighbour. Was that
That's correct.
consistent with your understanding
Yes.
of their relationship?
Yes, indeed, that is.
Thank you.
Thank you very much. I don't think we have any more questions. Thank you.
Thank you.
Thank you very much. And the last speaker I have in relation to Princess Highway Beverley Park, which is the RSL, is Christy Hodgkinson.
Thank you, Madam Chair, panel members, for coming to the site today. We are very pleased with the report that we've received from the council staff in relation to the development application. There's just two conditions I'd like to address, if I may. They're on page 350 of the LPP report. The first is in relation to the condition number 45, which relates to cashless gaming. Cashless gaming, as you're probably aware, is only in very much a trial capacity in the state at the moment. There is only one venue in New South Wales that is subject to the trial of gaming machines. I'm not sure whether the intent of the condition was purely around the cashless gaming system or around noise attenuation. The need for coins not to be dispensed into coin trays, I don't believe is in our acoustic assessment as being problematic. But outside of that, the club has looked to register itself for cashless gaming and has put their hand up for it, but the period that leads into that takes approximately 2 years before it actually comes into effect. We have spoken to the club about this directly today to make sure we understood what the potential implications were. If that was to take 2 years, we clearly wouldn't be able to trade in that period of time, which to us doesn't make a lot of sense given the infancy of the program. We also don't believe it that there's any significant noise impact based on the acoustic report that we've provided to the council, and condition 49 and condition 50, we believe, address the same intent as what condition 45 does. Condition 50, not condition 49, in relation to the amenity of the neighbourhood, where it does require us to be very conscious, obviously, of the emission of noise from the premises. So we would seek that condition was actually deleted. The only other condition that we would like to query is the need for an airlock at condition 48. There are other means other than an airlock to treat the separation between indoor and outdoor areas, including by mechanical ventilation, similar to an air conditioning type feature that actually operates over the top of the door frame. An airlock hasn't been included on the subject plans at the moment. We don't believe it's necessary. If the panel is of the view that it is, then so be it, but we would like to see that condition removed. We do have obviously requirements to comply with the smoke reactant regulations regardless. So,
thank you. Any questions?
Just a really quick one. With that, the coins in the tray, condition 45,
yes.
are you saying that your noise report has taken that into account, like it's been assessed that would happen?
That would have been taken into account as part of it. It's been assessed as an external gaming room, so I see no reason why it wouldn't have been accounted for.
Because you want that condition deleted?
Yes, we do.
Okay, thanks.
Thank you.
Judy, George?
Thank you very much.
You're done. And given that we don't have any more speakers on any items, just confirm that we don't. Council? No? Thank you very much. I'll close the meeting at, it's not 4, was it? No, it's, oh, it is 2, 4:40. Or 4:40, yeah. Thank you very much.